Good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series. Today, we are joined again by Mike Radan. And Mike, thanks so much for taking the time to join us. And this time, certainly, I want to talk more about your practice and the wonderful world of MPAC and the Assessment Review Board. So perhaps for anyone that doesn't know you, maybe you can give us a little background of who you are. And thanks again for joining us.
Great. Thanks, JP. Good to talk to you again. I'm Mike Radan, as you said. I work as an in-house paralegal at MPAC, the Municipal Property Assessment Corporation. We have a team we call, I'm a senior assessment advocate. That's my title. And my role is to represent the corporation in the litigation process when somebody appeals their property assessment. So MPAC is charged with valuing every single property in Ontario, from everybody's residence to commercial properties, industrial properties, Pearson Airport, government, everything. So there's approximately, I think, about 5.5 million properties in Ontario that MPAC values, with roughly $3 trillion that are worth about $3 trillion. So we work under the legislative framework of the Assessment Act, and I appear before the Assessment Review Board if somebody does appeal their assessment.
Now, before we kind of get into all of that, maybe you can tell us how you got into all this. It's certainly an area that, again, we covered in tribunals, in paralegal colleges, and a lot of people kind of wonder, well, could I get into that area? So, you're someone that's in there, and how did that come about? And tell us maybe a bit more about the Assessment Review Board and just sort of generally, MPAC as well. Kind of what more it does and how you got going here, and what it's like to sort of be in the position you're in now.
Well, we sort of say that assessment is the accidental profession. Nobody goes to does the paralegal program or goes to law school with the intention of practicing assessment law. I went to Trias College, did my paralegal program there from the fall of 2014 to the 2015, and then I became licensed. And in 2016, once I was licensed, I started in private practice. I did tribunal work, mostly landlord-tenant board, some labor relations board. I did some small claims stuff, a lot of employment law stuff in small claims, and some construction law. And then I just happened to have an alert on Indeed for paralegal positions that were out there, just kind of curious. And I happened to see a posting for what was then called case management at MPAC. And I applied, went through the hiring process, which involved a multi-person interview, a little bit of a test, and then and a background check. And then I was on contract. I worked on contract for about 1.5 years, and then I, applied for when a full-time position became available. I applied and I received that. So now we are called assessment advocates. It's assessment litigation and dispute resolution is our department in legal policy and compliance. So a mouthful. So that's basically. So I've just about a month ago celebrated my 5th anniversary at MPAC. So I found it really interesting work. Sort of surprised me as to what what it could be, and it definitely is I find rewarding and interesting, and also pays well. So that's always a good thing. A good pay. I'm well rewarded for what I do.
So maybe we can get a little bit more general about MPAC. Now, I know you were talking about it assesses and trillions of dollars and property value. So maybe you can tell us a bit more of, for anyone that's like, well, what is MPAC and kind of what is the role there of MPAC generally? I know obviously your role is a little different within the organization, but kind of what does MPAC do, and how does it fit into, assessing and the review board?
Sure. So essentially, like I said, MPAC is charged with placing a value on every property in Ontario. That value is then used by the municipalities to determine their property tax for that property. So if somebody is every MPAC will, when they do a general reassessment, and the last one was had a valuation date of January 1st, 2016. So or if there's been a change in the property or a sale, there might be a reassessment. But what happens is you receive your notice of assessment, and then if you agree with it, you file it and you pay your taxes when your tax bill comes in. If you disagree with that assessment, you can appeal it, and you file an appeal with the assessment review board. So generally speaking, like I said, it's MPAC uses market data. They collect market data, and that's how they determine values on the property. So mostly the residential properties will be done using what's called the direct comparison method. So they will directly sales of properties of a house that's similar to yours or a condo that's similar to yours will be used to determine the value. For commercial and industrial properties, are a little harder because they don't transact as often. And they're unique, right? So sometimes like industrial properties, say like a big automotive assembly plant, well, that's not going to sell. So we can't use sales for that. So what they do is we use what's called the cost approach. So MPAC has valuators that determine how much it would cost to build that facility. And then the other thing, the other type of property, usually commercial income properties, are valued on the income approach. So multi-residential properties like apartment buildings or commercial like plazas or those kinds of office buildings are basically valued using how much they're purchased for an income stream. So the value of those things determine on their income, their expenses, and the capitalization rate. So again, we have assessors that determine all those things, and they place a value on those properties. And then if those people, owners, disagree with the value, then they again appeal. And those commercial and industrial properties are the ones that MPAC's assessment advocates or paralegals get involved in to represent MPAC throughout that process.
Now, one of the things that I just learned just a few minutes before we started is that you mentioned January 1st, 2016, and people are thinking, well, hey, whenever my property at that time was worth a third of what it's worth now, does that mean eventually I'm going to be paying double or triple my property taxes because it's going to go up in value? So maybe you can kind of clarify, because again, I didn't even realize that has no impact because it's relative to all the other properties going up, and sort of how do municipalities then determine how to tax people based on the impact assessments?
So I'll give you like a quick rundown on that. I won't get into the weeds, but so what will happen is the municipalities, the council will set their budget every year, and then so they know how much money they need to operate. And then what they do is they take the assessment base in the municipality, and they divide that amongst that base. And each every property, in addition to having a value, also has a tax class. Like there's residential, commercial, industrial, farm class, various different property classification types. And then depending on which class it's in, it'll have a certain rate that the municipality sets in order for them to collect the money that they need to operate. So as I said, the assessment is used more for the apportionment of how much you pay, not necessarily so having an increase in your assessment doesn't necessarily mean that if your assessment doubles, doesn't mean that your property taxes are going to double. If all the other properties in that municipality have also doubled, then your taxes will stay the same.
Yeah, that's very, very nice, very succinct there to kind of understand it because again, I mean, unless your property for whatever reason tripled and everyone else is only doubled, then you're
Yes.
not going to see much of a difference.
Like as
And
an example, sorry, I didn't interrupt
yeah,
you. But if your property, if you built in a, if there was all the same house type of house on your, in a subdivision, and then you added an addition to yours and other people didn't, well, obviously yours is going to be worth more. And so, your model, you'll pay a little bit more. So, or added a pool or something like that.
okay. And the other thing that comes up is valuation dates and valuation cycles. So how does that kind of factor in of when MPAC and sort of then that in data goes off to the
Mhm.
municipalities? How does that impact everything going
Yep.
to from
Yep.
MPAC to
Well,
the ARB?
yep. So what happens is that, well, the impact returns the roll every year to the municipalities. So there's any updates or sometimes like new houses get built and things like that, or new so impact does that every year, updates their data and returns it to the municipality. But there's every I would say typically every 4 years there's a general reassessment. The excuse me, the last scheduled one was postponed due to COVID. So, and it's set by it's not set by MPAC, it's set in legislation and regulation by the provincial government through the Assessment Act. So the last general reassessment was done in 2016, or actually was done in 2017 with a January 1st, 2016 valuation date. So even in 2023, when we're assessing properties, we're trying to figure out what they would have been worth on January 1st, 2016. So I have right now, I'm dealing with a number of properties that have been built, in the last year or two, and the owners are appealing their assessments, and we are trying to determine kind of what they would have been worth in a time when they weren't even built yet. So it's a little tricky, and kind of open to interpretation in some cases. So we're waiting an impact for the provincial government to let us know when the next reassessment date, general reassessment date, will be. And I'm sure that property owners are also eager to get that, have another reassessment more, that's closer, and maybe has data that's a little easier to apply.
Now, with respect to the appeals, right? So,
Mhm.
are in your thinking, I don't know if it's just generally or specifically in terms of what you're dealing with, but where are the bulk of the appeals kind of coming from? Are they residential? Are they commercial? Are they farms? Like, what are you typically getting?
Yeah, I'd have to, I would actually have to kind of look up the stats as to how many appeals the ARB gets in a year. I think I'm trying to see if I've got it handy, but I can't. Don't seem to be able to pull it up. But so I think typically, like, uh, the there are two streams, or there are two streams of appeals. There's the general stream. There's a summary stream, which in as the name implies, it's sort of a shorter, faster way. And property, it depends on the property type. So residences, farms, managed forest, and conservation land is in the summary stream. So that's a relatively fast process. It's sort of a homeowner will file an appeal. They'll let MPAC know what their issues are, why they think their appeal is, why the properties should be lower, why the assessment is too high. MPAC will respond. They'll have, and the response is done by, in the summary stream, is done by the assessors. MPAC doesn't involve its litigation team in that. So the assessor will respond to the homeowner. They will, either respond as to, if the issues are valid, they'll lower the assessment. If they don't agree with those issues, they'll let the homeowner know why. Then there's a what they call a mandatory settlement meeting, which people are probably familiar with that, in a very self-explanatory term, where they try and come to a consensus. And I would say that I believe it's something like 95% of appeals do settle before a hearing. So so typically there's that they get resolved before they have to actually go to a hearing. And so then if they can't be resolved at that stage, they go to a hearing. Now in the general stream, that's sort of all the other property types that are the more complex, like multi-residential, commercial, industrial properties. And they're a little bit of a longer process because information needed to value them is a little more complex. So same thing. What happens is that the appeals when they get filed, the ARB assigns them what they call a commencement date. And once that commencement date starts, then the appeals start, and MPAC does their initial disclosure. The appellant then files their pleading, which they call a statement of issues, which again outlines what the issues are and what they think the value of the property should be and how they calculate that value. Then MPAC has an opportunity to do its pleadings, which it's called a statement of response. MPAC responds to those issues, and then again we hold a mandatory settlement meeting at that stage. And if we can agree, that's great. If we don't agree, then either we go to a hearing, or the parties can decide that they might need expert reports. So the evaluators need to kind of sit down and do an expert report. And then once those expert reports get filed with the board, then the board sets up a settlement conference where what they do is they have a member there, and all three parties are able to attend. So that's the one thing that's unique about assessment appeals, is that there's MPAC, there's the property owner, and there's also the municipality, are all statutory parties. So at the settlement conference, everybody lays out their position. It's sort of a without prejudice attempt to resolve the issues. And I would say a good, again, like over 95% of the appeals get settled at that stage. And if for some reason we just can't come to agreement, then the parties set a hearing, or the board sets a hearing date, and the parties, we do a case management conference, and we have a hearing.
It's a nice, quick kind of way to walk through those two streams there. Is there, I mean, I guess before you even go to the board, so is there a way to kind of maybe even just deal with it at MPAC, where, I say, essentially, I disagree with the assessor, maybe can you reconsider this? And, I don't necessarily want to go and appeal it, but, is there a possibility, even on hardship or something like that you can go back to MPAC and they can look at it again?
So there actually is, there's a process called a request for reconsideration, and that's actually it's open to all property owners, but it's actually mandatory if in the summary stream. So for things like residences and farms, the property owner has to first submit a request for reconsideration. So that's sort of almost like an internal appeal, if you will. And it's it goes to the assessor. The assessor looks at it. Again, you state the property owner would state why they think the assessment is too high and what they think the value should be. And so oftentimes those appeals get resolved there through minutes of settlement. And then if not, then if they're, like I said, in the summary stream, then they get filed with the board. With the general stream properties, they can do a request for reconsideration, and some property owners do, but it's not mandatory like it is in the summary stream.
Now, in comparing the general and summary stream, and certainly, you mentioned that there's going to be more disclosure and expert reports and things like that. What's the timeline in terms of processing time with one versus the other? Approximately?
Right now, so it's I'm not as familiar with the summary stream because I don't, like, again, our advocacy team at Impact doesn't deal with those appeals generally, like unless there's a specifically unless there's an issue that's really has some broader impact other than just on that one property. Say something that may affect other properties as well. We might get involved, or legal counsel might get involved. But so generally, I can't, I don't off the top of my head know what the summary stream is exact in number of weeks, but the new the ARB instituted new rules in 2017, and they've actually been refining them since. And the new process for the general streams, or start to finish, is ideally, perfect world, about 1 year, if it goes to a hearing. So if it doesn't resolve, if the property doesn't resolve through, one of the earlier stages, like the mandatory settlement meeting or the settlement conference. But generally, it would be 1 year from the start of the appeal to the resolution at a hearing.
Perfect. So let's kind of break down then some of those steps that you had outlined
Sure.
earlier there. In terms of disclosure, right? So again, let's focus on the general stream, because that's
Yep.
sort of where the bulk is going to be. So let's say a commercial property, or multi-residential kind of property. What are they? Essentially they're bringing their stuff first. I'm guessing, or maybe it's coming from Impact first.
So MPAC, what happens is that MPAC does their initial disclosure first, and that's basically the what they do is we have the all the property information. How we arrived at the assessment is disclosed to the property owner, and that's done right now for the most part. That's done through MPAC has a portal and called aboutmyproperty.ca. So all of that information is uploaded to that. All the information on a property is on that, and also comparable or neighboring properties as well. So I believe, so a property owner can go on to aboutmyproperty.ca and look at how the value for their property was arrived at, and they can determine it, and then they can see if they have any dispute with that. Then they file their statement of issues, and or serve their statement of issues, which again outline why they think the assessment is too high and what it should be and how it was calculated. So then once MPAC receive that statement of issues, then we do like what we call a triage of that, and we kind of look at it and say, do we need any information from the property owner on that? So, if the property owner, let's just say as an example, it's an income property, and MPAC says the rent is $1 a square foot, and the property says no, it's too high. It should only be 50 cents a square foot. So we might request to look at their rent rolls or their financial information to determine that. And then again, we look at it, and then if in some cases we agree with it and say, yeah, you're right, your pleadings, at MPAC, our goal is not to our goal is to get the correct current value of the property, whether that's a decrease. It's not to defend the value that was returned on the roll. That's not our role. It's to come up with the correct current value. Sort of we have no skin in the game as it is. Like it doesn't really matter as far as MPAC is concerned. We just want the correctness. We have no stake. And, if a property goes up or down in value, we don't benefit from it at all.
And in terms of, I guess, then once they've kind of given their disclosure, or whatever you've asked for in relation to something like that, like a rent roll, what else? I mean, in terms of the statement of issues, I know that you're looking at, and then your response, and then their reply. I mean, is it consisting of like legal arguments there to sort of supplement the information that's given? Or
yeah, absolutely. There's some things like sometimes there's the issue is the tax class, right? It's how the property should be, so, and sometimes some properties have multiple tax classes in it. So it might be a case of, how it's apportioned. It might be, so then it becomes a legal argument as to when, what is happening in that space that does it meet the criteria for that particular tax class that the property owner thinks it should be in, right? So then it becomes an interpretation, or in some cases, we also do one of the things that's happened because there's been a delay in the assessment to general reassessment. Typically, you can only appeal your property once in the tax cycle, in the assessment cycle, and then once the value is set, it's set for the entire cycle. So what's happened, because of COVID, there were some property owners that felt like COVID was a change in their property and the state and condition of their property, so that they wanted to appeal their property assessment a second time, because there was a change in the state and condition of their property. And there was a number of decisions that the board made that went to there was a couple of decisions that the board, a couple of properties that the board heard the arguments. MPAC asked for them to be dismissed based on issue estoppel, and so then the board heard those arguments, and then those appellants appealed to divisional court, and there were some properties that did judicial review instead, and anyway, they made a determination. So then now we have some other property owners that, again, we might have, like, we look at it when the pleadings come in and say, oh, look, like this property's been appealed already once this cycle. So is it a case of issue estoppel, or is there some new issue that or maybe it's a different party, it's the property's been sold and the new property owner wants to appeal, so they don't meet the requirements of estoppel. So there's those are some issues that we run across, like legal issues that we would run across, and that's just one off the top of my head, but sometimes other ones crop up as well.
You'd also brought up expert reports. So, I mean, where would the experts kind of come in on, I guess, either side? I mean, I don't know if you can give me an example of something, I guess, probably very complex, where, you'd need the experts to kind of weigh in to help sort of sift through what's the real value of the property.
Yeah, well, it could just be, so as you know, the difference between an expert witness and a fact witness is that an expert witness is able to give, is able to give opinion evidence, right? So in some cases, we might have experts and they might agree or they might disagree on, in their opinion, this property, should be valued at, they just have a different opinion on the value of the property, and or they might have a different opinion of what the tax class should be or something like that. So, which is actually, the tax might be more of a legal argument, but just on the value, they might have, there's, like I said, one of the things, because I do a lot of income properties, sometimes there's disagreement among experts as to, what the rent should be to determine the income. I mean, I actually have that coming up I have a sort of a three-part, I have actually an appeal coming up in the fall, where the municipality actually appealed the assessment. They thought it was too low, and so they thought, and it's an apartment building, so they thought that the rents that MPAC was using to determine the value were too low, and so they put their expert, did a report and gave his opinion of what the rent should be. MPAC's has their opinion, has their expert and their opinion, and then the property owner also weighed in, and he thinks, the property owner, or they think, that the rents that MPAC's using are maybe a little too high. So, it's kind of a three-part, and then, we'll go to the board. The three experts will weigh in and assist the board. Again, the expert witness has a duty to the board to assist them in coming up with the correct current value, as opposed to a fact witness who just states the facts.
Now, I mean, one of the things, I mean, maybe related to that is, and we always get this bullet there in the course there about paralegals can kind of be witnesses, if they're also valuation experts and, representing, I guess, on either side, that they can essentially testify and then go back and to put their paralegal hat on and then start questioning or talking to the other witnesses. So how often do you see sort of, paralegals, and maybe we could kind of transition more into getting into the field where they have a background in valuation and then they're like, hey, I got my paralegal license. This is a great career for me. Double up.
There actually are a number of people at MPAC that working in on our advocacy team that actually started as valuators, right? And it definitely helps that having a knowledge of valuation assists you as an advocate. So in assessment in the appeals, in the summary stream, so that the which is generally the paralegal can testify to the facts of the case and can also sort of do what's called, we call it the dual role. So they can be a witness and an advocate. Now, when you get to the general stream, if a paralegal wants to be a witness and an advocate, they have to seek leave from the board and be granted that. And now, if they have there's an inherent conflict between so a paralegal or a lawyer couldn't be an expert witness because there's a conflict between their duty to their client and their duty to the board as an expert witness. So in the general stream, a paralegal couldn't be an expert witness. And actually, funny enough, there are some paralegals that are evaluators, but they strictly, I actually have one property under appeal right now that I'm handling that there is the evaluator happens to be a paralegal as well, but he's actually only acting as a evaluator. He's not acting as an advocate. There's actually a lawyer retained to be the advocate on that file.
Great. Now, you were telling me about meetings, and obviously there's potential for mediation and things like that. So kind of in terms of preparing for that mandatory meeting initially, so is MPAC and the appellant, sort of the ones there, is the members of anyone on the board involved at that point, or how do they get involved in terms of trying to get settlement?
There are two opportunities where we kind of in some cases we will have ongoing settlement discussions and settlement offers exchanged back and forth, and that through there's I mean, as you know, as licensees, we have a duty to try and settle matters, right? So there's always ongoing discussions about, once the pleadings are exchanged, there might be like, we'll look at something and make an offer, or the appellant will look at something and make an offer, and then we'll weigh all the various things, and we'll get instructions from the valuation team as to whether we accept an offer or not. But but more formally in the process, there's the mandatory settlement meeting, which happens after the pleadings are exchanged, and that is just the parties, right? That's just an informal between the parties. Actually, I had one today, and it was we got on, and actually it turned out that there was some corrections to the assessment that the property owner requested, and MPAC's evaluator looked into them, and they were correct. So they gave them those adjustments, but then at the same time found some other mistakes and corrections in the assessment of the property, which actually would have led to a little bit of an increase, a small increase. So the appellant decided that, we're going to withdraw our appeal, and MPAC had no objection to that. So we settled it informally amongst the parties. If that doesn't occur, then we file our pleadings and our reports with the board, and then we go to a settlement conference. And at the settlement conference is when there's a board member present. And at that time, what happens in a settlement conference is each party will state their position. They'll let the board know if there's been any ongoing settlement discussions and where we're at. And then the board, the board members looked at the materials, they have an opinion, and then what they might decide to do is caucus with one of the parties and say, I want to talk to the property owner. And then they'll take the property owner, into kind of everybody go. Well, we typically do those on either telephone or Zoom. So they'll either, we'll leave the call, and the member will caucus with the parties, and then they'll come back, after, when they're done caucusing, the other parties will rejoin. We'll continue the settlement conference. And then at another point in time, a member might say, you know what, now I want to talk to MPAC, and then look at it. And in those, when we caucus with the member, they kind of give us an honest assessment of the strengths and weaknesses of our case. And so with that knowledge, we kind of make an informed decision of where, how flexible we should be with our settlement discussions. And one thing I'm not sure if I've kind of clarified, but as an advocate at MPAC, I take instructions from, so my client is the valuation manager or the valuation team, and I take instructions from them whether or not to accept an offer. I don't make those decisions. I'm just the advocate on the file. So.
Yeah, and I guess maybe before we talk about the sort of the actual hearings, we're talking mostly about assessment appeals, and then sometimes obviously it might not be about the assessment, but maybe the way it's calculated on the tax side from the municipality. So do you sometimes, or sometimes it could be both, I suppose, I don't know, maybe not, but maybe could you clarify what the difference between an assessment appeal and then a tax appeal would be?
Yeah, well, there is no, like, the assessment review board doesn't deal at all with tax appeal. Like it's never, I pay too much property taxes is not an issue that they're concerned that the assessment review board. So that's not a reason to request a lower assessment. So they're sort of divorced from each other. There's not assessment appeals don't have anything to do with how much you pay in property taxes. There are a couple of the assessment review board does also do, and again, typically MPAC doesn't get involved in these, or actually not just typically, but doesn't get involved in these. And there are cases where if there's like hardship, if a person is meets certain criteria, they can have their property taxes reduced or waived. So but those aren't things that I do at MPAC. That's really more or less between the property owner, the municipality, and then they do hearings. And I do see decisions come up on those, and sometimes I'll read them for interest's sake, but they're always done in such a manner as to the individuals, the property address is not disclosed, the name of the property owner is not disclosed. They're just used initials, things like that. So there are some cases like that the assessment review board handles, but that doesn't have, we don't do those at MPAC.
And so then the bulk of probably what the board is doing are the assessment appeals involving.
Yeah, that's right. Then. Yeah, there are a couple there, like I said, there's some cases like that. And then there's also, there's a section of the Assessment Act where, again, if there's a fire or a flood or some sort of reason that the property can't be used at the time, that the property owner can appeal, but those are between them and the municipality.
And I guess in the earlier example you'd given is when maybe the municipality doesn't agree with the assessed value, they can also appeal rather than the owner of the property. Like, if they feel, hey, you've under assessed this property and now we're losing out on our taxation because of how we base it, then we'd want to bring it to the assessment review board rather than someone essentially saying you've assessed it too much.
Yeah, that can happen. It's not that often that it happens. It, you know, I happen to be dealing with it that where it is, but generally, those are pretty rare. Like in you know, so in assessment appeals, there's I'm not sure if I clarified earlier, there's three statutory parties. So there's MPAC, the municipality, and the property owner. They're all, like, typically in most appeals, it's the municipalities don't get actively involved, but they are still statutory parties, and they can, now if the municipalities don't serve a response or a pleading, then there are some constraints on what they can do. If a party doesn't serve a pleading, then they're deemed to not object to a settlement if the other parties agree to something. So the municipality couldn't, if they don't serve a pleading, they can't hold up a settlement, for as an example. But they are still, like, they can, even if they don't serve a pleading, they could go to the hearing. They could ask questions of the witnesses, but they can't put any evidence in.
Perfect. Now let's talk about the hearings then, and I guess since probably
Sure.
COVID, the process is maybe a little different. So tell me kind of
Nope.
how, in the event it gets to a hearing, what's that like? The day of the hearing and how everything
Sure.
sort of unfolds.
So there's typically there's half day hearings, which half day and full day hearings, and sometimes multi-day hearings. But the ARB, the Assessment Review Board, was actually going away from in-person hearings even before COVID. The default back in, I think it was 2019, they started to do electronic hearings as the default, either by telephone or by, at that time, Microsoft Teams. And then after COVID, that sort of accelerated the process, but really still, like, even back before COVID in 2019, 2019, the only way to get an in-person hearing was if you could show exceptional circumstances, so that you needed a hearing. Otherwise, it would be conducted by telephone or by video. So typically, what happens in a hearing, and so the hearings themselves now are all done on Zoom. So the ARB has sort of gone with all the other tribunals, Ontario, and they use the Zoom platform. So what happens is, everybody signs in, the members, look at take attendance, and then start the hearing. So MPAC has one of the unique things, even though the property owner is appealing, it's MPAC has the burden of proof. So MPAC has the burden of proving that what the correct assessment is. So so MPAC is the first to present their case in that case. So typically there'll be an opening statement, but might be, sort of 5-10 minutes, and MPAC will do that, then followed by the property owner or the municipality, sorry, and then the property owner goes last in the process. And then once the opening statements are done, then MPAC calls their witnesses. We do an examination in chief, and then the municipality and the property owner have an opportunity to cross-examine the witness. Once the cross-examination is complete, MPAC has an opportunity to do any redirect. Once MPAC has presented its case, then the municipality, if they have submitted pleadings and filed evidence, they can present it. If not, it skips over them and goes to the property owner. In any event, the property owner always goes last. That's in the Assessment Act. The last word always goes to the property owner. So they'll present their case again with their evidence in chief, and then MPAC or the municipality can cross-examine their witness, and then again they can do a redirect. Then we do closing submissions again in that order again, and then the board typically reserves their decision and then issues it at a later date. That's sort of a hearing in a nutshell.
Yeah, pretty good there. So I mean, you have three sort of parties, which is
Yeah,
a little different, right? Because
it is. It is.
you know,
And again, I would say there's a very small number of hearings where municipalities even attend the hearings. Some attend and observe, and an even smaller number attend and are active participants. But it does happen sometimes, like they'll also sometimes hire representatives, be they either paralegals or lawyers.
yeah, so I mean the vast majority then, of anything that does go to a hearing, you're going to
Mhm.
have MPAC on one side sort of presenting first, and then in the rare cases, the
Yep.
municipality may, even if they're there, they may just kind of be
Yep.
observing and taking notes or
Yep.
something, and then
Yep.
the property owner, depending on the property,
Hmm.
obviously the general stream, will then cross-examine, and then they'll go
Hmm.
through their case and
Yep.
make their submissions. And then how long typically are you waiting on decisions
Um,
once they're
I would say,
reserved?
you know, I'd say, a couple of months. Depends on the complexity, I guess, of as all tribunals, right? Depends on the complexity. Depends on the members. They have to, I don't know you know, I don't know the inner workings behind the scenes of members and boards. So I don't know. They have to take all the information that they have that they hear at a hearing, and then find the time to go through it and then write their decision. So I say typically a couple of months, but it might be a little bit longer.
Now, for anyone that's interested, obviously, like I said,
Hmm.
it's covered, and then people might be interested, and then
Yep.
it's hard to find people like yourself compared to everyone that's in provincial offenses,
Yep.
small claims, and landlord tenant, the big three. That there's a lot more practitioners there, but
Yep.
I mean, in terms of maybe kind of like a day to day, I know obviously every day is different, and
Hmm.
you're telling me all these things that you did,
Yep.
settlement, I did this and that over the last few days. What are the kinds of in terms of being improving your sort of skills or getting involved on the impact side, what would make a good paralegal that you'd be looking for, and things that they can develop between now and
Hmm.
whenever there's a big posting that they're
Yep.
hiring?
So for sure. Well, there's actually one of the things that MPAC does is that there's sort of a stepping stone. There's I think there's around 50 to 60 paralegals, advocates at MPAC. Um, but there's also a number of, I think it's about 10 or 15 legal assistants who help out. And it's not a requirement, I don't think, for that position, but it's preferred that they be licensees. So so typically what happens, like actually my former assistant is now an advocate at Impact. So she started out, she applied to an assistant position, and then she got to know the process, got to know about the board, about assessment, and then when an advocate position came available, she applied and was successful. So that there's that sort of thing at Impact, a little bit of a place to get in and learn, and then move on. But I would say, like, I look at the skills that I use from the time I started, and one of the things that uh, I think it's probably like everything else. You could hone up on your research skills, right? It's always good. You have to find at the end of the hearing, you've submit case law to support your position, just like you would in any other venue. So you have to, the board relies on precedents, whether sometimes they're from the board, or from divisional court, or from the court of appeal even. Research skills are good. And then the other thing that I find useful is drafting. If you're good at, hone your drafting skills. I know one of the things when I started at MPAC, so for the first, I don't know what period of time that was, but for the first while I working at MPAC, I was sort of the person that I was always assigned a lot of motions, so that were being done, like respond, typically responding. Like sometimes a property owner had missed the deadline to file an appeal, so they were filing a motion to ask the board to grant them time to file their appeal, and then I would be given the task of responding to their motion. So I ended up having to draft those did a lot of drafting of motion materials. So like I said, those things you can hone, and then just like all your other advocacy skills, whether they be oral or written. There's a lot of the motions at at the ARB are all done in writing, so it's always good to hone your writing skills, right? So yeah, all those same things that you would use in any other area, I think.
Now, I know I said we wouldn't touch on that sort of, your
Sure,
role
no,
now as the bencher, but I think it's kind of related to both here. But
sure.
I know one of the things the law study certainly was looking at was, getting more, funneling more paralegals out of those three areas we were just talking
Hmm.
about.
Yep.
And what more no, I know certainly you just highlighted some skills there, but
Hmm.
about these opportunities, right? Whether it's at MPAC, whether it's for appellants, right? I know you.
Hmm.
I don't. I think. Well, I don't know if we actually were talking about this before we started or
Hmm.
after, but you mentioned that there's a lot of paralegals that are representing
Hmm.
the appellants, right? Not
Yep.
just the 50 to 60 that are
Yep.
at MPAC. So, where would you sort of give that kind of looking to maybe doing an internship, maybe
Hmm.
connecting with other paralegals in the field, but sort of that there's all these other opportunities in the areas that you're
Yep.
practicing that tend to go unnoticed,
Hmm.
especially because we're seeing paralegals, if they can't get into those big three, they're like, oh, it's not working out, and maybe I don't practice or use my
Yep.
license. It's just a larger concern that we don't necessarily need to.
Hmm.
We could have a whole topic,
Yeah.
on that another day, but how to kind
I'm
of
happy to have that conversation anytime.
how to kind of get more of the notice
Yep.
that there is this area, and
Yep.
what to do sort of to
Hmm.
kind of get in there besides those skills we were just talking about.
Sure. You know what? I'll give you a two-part answer. The first part specific to assessment, and then something. The second part, sort of, which I think is the kind of my, I don't know, close to my, something I really want to advocate for is for paralegals to do more work in other areas other than just what we call the big three: landlord, tenant, small claims, and POA. So the first thing in assessment, like, honestly, I didn't know anything about it before I started. I know I've been a homeowner for a number of years before I was a student, and we briefly covered. We touched on MPAC and the ARB in my administrative tribunals course, and but I really didn't know much about it beyond that, beyond whatever it was, and I when I started, like, kind of learned on the job. But I also didn't know that, like you said, there's at the time when I first started, there really were not that many paralegals at MPAC. It was really over the course of time, over the course that I've been there, I was kind of the first group that was hired from outside of MPAC. And then, ever since that time, the philosophy at MPAC has been to build a robust legal in-house team with paralegals. Like we have 50 or 60 paralegals, and we have like 3 lawyers on, like, in-house. So it's like really, and one of them is our, like, VP and general counsel. So really, like, we're really paralegal heavy, and that's been, we've shown that the paralegals at MPAC have shown that internally to impact that we can really do this work, and we're good at it, and that you don't need to be a lawyer, because before I started it, I think there's something like 60% of litigation went to external legal counsel, and now it's down to like 10%. So really, like, we do a lot of appeals in house now, but there's also, like you said, there's a whole other side to it, which is the property owner and municipality. There's smaller on the municipality side, but for the property owner side, I would say that over 95% of the representatives that I deal with are paralegals and not lawyers. So it was there are a couple of big firms. There are a couple of firms that would shock you that the size of them. Like there's one company that is traded on the Toronto Stock Exchange, and it has a paralegal division, and that paralegal division appeals property tax assessments. And I don't actually honestly even know how many paralegals they have on staff, but they have an office in London. They have an office on Yonge and Front Street. They have an office up in Aurora, in Toronto, and I think I'm not sure if they have any other offices throughout the province. But so they're a huge paralegal. I had never even heard of them before I started working at assessment, and I would bet you if you went to the LTB or POA or whatever, asked all those paralegals standing around in the hallway like we used to, have you ever heard of Altus? Nobody would have any idea, and yet they're this huge paralegal firm. So there's others as well that are out there. So I mean, I guess you could do some research, Google I want to how to appeal property tax assessment, and maybe those firms will come up, and send out your resume, start applying to those, right? So on the assessment side, that's what I would say. And always, like I said, at MPAC, they periodically post either on their website or on Indeed or whatever. So, keep your eye out for that as well. But the other thing, like we were talking about working, there are a large number of tribunals that paralegals can represent at. The big issue to me is how do you make how do you put food on the table, roof over your head doing that work? Because we can do professional regulation as an example, right? And there's no issue. We can appear before any number of regulatory colleges, including the Law Society. Yet very few paralegals do that work. And I think part of the reason is that when somebody is in trouble with their regulator, they don't typically think of like, hey, I'm going to go to a paralegal. They call like, I'm going to call a lawyer. If my license is on the line, I'm calling a lawyer. So I would suggest is that those paralegals, if you're interested in those other tribunals, or like Ontario Land Tribunal, or any of these other things, find a lawyer that works in that area. Go work with them, learn from them, and then you can either stay with them or you can go out on your own after that. But find a mentor, be it a lawyer or another paralegal working in another area. Work with them, and then learn, and then go from there.
Perfect. So, Mike, thanks once again for taking the time and joining us. Always a pleasure, and certainly always great to learn about other areas that, that again, we kind of, as you mentioned, just kind of touch on, and it's good to get more practical knowledge from people practicing about sort of the nitty gritty there behind the scenes. And especially as we walk through a matter from, when you assessed it all the way to a hearing, and potentially a divisional court appeal, as you said, might be happening for some of the stuff you're working on. Any final words of wisdom? I know there's a lot of great advice just right in the last couple of questions there, but anything more you want to add for any of the students or newly licensed paralegals listening?
Yeah, I think I would just well, first off, thank you for having me on. It was great. I could talk to you, get into the weeds. I could talk to you about this stuff for like another hour. I'm sure that nobody wants that. But in any event, like I'm always happy to talk to you about whether it's MPAC, assessment law, what's going on as a bencher or anything like that. I'm always happy to talk to you, JP. It's I think your series here is great. As far as like I said, with I think one of the important things with new people coming out of coming out of college and getting licensed is I find it like is find a mentor. I think that's the most important thing. I know that I know it was like when I started out, I started out in private practice, and it was difficult because there was, sometimes you don't have you don't always have somebody to bounce stuff off of, that kind of thing. And I found that when I started at MPAC, there was already a team there that had, was experienced, and there was a number of times like you just, go over to somebody's office or into their desk and say, hey, hey Bill, like what do you think, what like, you ask them a question, they give you the answer, and for next time, right? And with it, you can work like that. So I think, find somebody, whether you work for them or just a mentor in general, and somebody you can bounce stuff off of is key to success in your paralegal career. So find somebody, and the Law Society has a coach and advisor network. Take advantage of it. Like, you're paying your fees, it's there for you to use. I don't believe there's a cost. I'm pretty sure there's not, because they really promote it, and it's like I said, it's beneficial. I'd say it's the number one way to key to success.
Perfect. So once again, thanks so much for taking the time, and thanks for everyone for tuning in. Take care, everyone.
Thanks. Bye bye.